Hi, ladies and gentlemen. Welcome back to the SAP Business Talks. We had a little break. We had to change some of our organizational issues, but now we are happy to be back with a continuous stream of live interviews. And we start that today with Volker Tillmann. And we will talk today about investor readiness, IP investor readiness. In this case, especially for scale-ups, but I think that is a fascinating topic. And before we start, just to take care that you know that this is a live show, that this means you have the opportunity to write comments in LinkedIn under this video stream, and I can see that, and I can bring you to the show with your comment, with your questions, and you are very welcome with that. So today, Volker is with me, and Volker is partner at Hoffmann Eitle, and he lives this topic. So he really is in that field with scale-ups to help companies to become investor ready with their IP issues, and very happy to have him to discuss a bit deeper what that means and what are the challenges of that. But before we start with that, Volker, just tell us a little bit, how did you came into this, strange field of IP?
Yeah, thank you, Alex. Well, I think everyone who is active in IP did not start his study or even school with the idea of becoming a patent attorney or someone who is active in this field. In fact, I learned only about IP when I was already during my physics studies. At the time, I studied physics, which was somehow an accident, as you may take from my background. I'm a fan of aviation, and I actually wanted to become a flight pilot or a flight controller at the time. When I then moved over to physics, I didn't really know why and for what. It was more or less my plan B for several reasons. And at that time, my girlfriend studied law, and one of my friends who was present on the airfield where I used to fly, he said, well, Volker, then the couple of your girlfriend and yourself, you are a patent attorney, basically. And I said, well, what is that? I didn't know about that job at all, and that was maybe the start to me then being interested in the field, and did an internship with a law firm or a patent attorney boutique in Wuppertal, which is where I grew up. And then somehow life is sometimes a bit unexpected, and my ways brought me via Switzerland to Munich, to Hoffmann Eitle, and now I'm in Düsseldorf for almost 13 years. Having co-founded this office here, and because the Düsseldorf office of Hoffmann Eitle is somewhat specialized for local direct clients, some of them are startups or scale-ups, at least high-tech companies, and that is how it came that I got a bit more involved in the topic of IP readiness for investors in particular. Because as we will maybe see today, this is something where you cannot be carefully enough, actually, when you start your business, when you start your company, that you need to be prepared for the next step, not only the immediately following step. And for that I think it is good to have a proper advisor alongside you, so that you can, you don't make the mistakes everyone does in the first place.
So maybe we start with this terminology. So everybody has heard about startups, basically. So even then, the definition, what is in which financing round a company is, and is it stage A, stage B, and always a bit tricky. but not so many people are familiar with the term scale-ups. So what would you say? What is the definition for you? Where do you think startups and scale-ups are a bit different, and especially in IP terms? So when is a company a scale-up?
Yeah, it is difficult to define a proper point in time where you have to change your description if you want. I think a scale up is a mature startup which has grown already for quite an amount, and where it is no longer the case that you have to find your initial products or the initial markets and find your way through the entrance barriers to a market, but you're already there. And that is then the point in time where if you're successful with your products, then you are growing really, really fast. And that is also the challenge of these companies. The speed of growth is something which somehow sometimes overtakes yourself. So if the company, the firm is growing faster than your structure grows, then you're getting into trouble. In particular, when it comes to IP, where from my experience, startups in the deep tech scene oftentimes start with an idea, maybe 2 or 3 ideas, but basically one concept, one product, where many things evolve around. And then the focus is, of course, on putting that product on the market, finding the first investors for being able to do so. And then you start hiring your first developers and so on. And with that, normally the let's say innovative power also grows very, very quickly. And whilst as a startup, you have done your first invention and development normally before you enter the market during the scale-up phase, and that is maybe one of the biggest differences or most remarkable differences during that scale-up phase. As you grow, you are also expanding technically and in terms of innovation. And for that, you make, or in order to not lose sight of your inventions and the developments that you have to offer, you need to find and develop a structure which helps you harvesting all these inventions, so getting to know the inventions, because you're no longer a one-person show, and for that it is of course very important to have a structure which helps you not overlooking important aspects of your team.
Got you. I mean, this is basically what I have learned here from your Dplex page. So this is for all of you who want to read about that more. Volker runs here his own page on this specific investor readiness issue for scale-ups. Maybe that is also relevant and interesting. We have a first question, Maria. It was very good to see, Maria, that you are here. I hope that this is your topic, so to speak. So she says that there are certain warning signals in scale-ups to whether they are investment ready or not. And so what would you say? So do you know such warning signals where you say, okay, we should jump in, so things are not okay here and you are not investment ready, or the other way around, when you say, okay, that's a tick box, that's fine, that's okay, when you have that, we can proceed?
Maybe that's a very good question. One of the warning signs is that if you are being asked by a colleague or by an investor, maybe, what is your IP for? So where are the products where can I find the IP for your products? Where can I find the products in your IP? Which markets are you addressing with the IP? So that if you have structured questions and you're not able to immediately answer them, or at least know where to find the answer to these questions, then this is the first indication that because you should be prepared for these questions when inventors come along, that you are not yet in good shape. I think many firms start with ad hoc filings, as I put it on the Diplex page. Ad hoc filings, what I mean by that is that the inventors come with an invention. At least in Germany, you're obliged to file something unless you give it to the inventors. And then you do these filings, but you don't have a plan. Why are you doing that? In which countries are you doing that? Which products are behind that? And all this. And that only comes up if and when an inventor gives you or indicates that there has been an invention. If you want to be more structured, then you should establish something like a continuous IP management system. And by that, I don't mean a software. I mean something that is a process in your firm where you regularly meet with those people who might be inventors and ask them, also direct them to a certain direction where inventions would be particularly handy for your business strategy. So aligning business strategy and IP strategy is also something which comes to mind if you think about inventor readiness. If you can show that your IP is aligned with the business strategy, so you know why do you have these IP rights, then it's a good indication. If you're not so structured, then it's difficult.
And how do you deal with this trivial answer of, we have that because we want to protect our inventions? I mean, that is redundant and meaningless, but that's often the answer for the IP strategy. So how do you deal with that?
Yeah, that is of course a difficult one. It is not for me to decide for the client which IP right they think are important and which are not. I normally try to make the clients aware that this is an expensive hobby. They know that themselves, but the reason why I say that is that there is of course a price or a price tag to all these IP rights. The question is, what is the value behind that? And if there is a difficulty in answering what the value is, then we should dig a bit deeper and think about why are we filing these patents? To protect something that is not worth protection is not a reasonable business strategy and not a reasonable IP strategy either. So there should be at least a formulation or an attempt to state why is that of importance. It's not important because someone invented it. It is important if it serves your business strategy.
Yeah, and I think exactly what you said. It's the value. When you have a value discussion, value means future economic benefit. So then you cannot go to bypass that and say I'm protecting inventions, because that's true and meaningless at the same time. But when you have a value-oriented discussion, we have to explain what creates here the value, where lies that in, and this can only be answered within the context and the framework of the business model, and then it makes a lot of sense. Okay, I think I think that's important to guide them a bit, beside of the trivial answers, which unfortunately not help, so to speak, or also not for investors basically. So
Maria answer maybe is that your margin and your profits are statistically at least higher if you have something protected. That's of course the case, but again, this is only one piece of the puzzle, and it doesn't help you to get an overview of what you're doing in the IP department if you have one.
Yeah. So Maria has another question, which I think is also very, very relevant here. She says, sometimes patents are just filed, like crown jewels, or to signaling, to showing we are inventive, and it is proved from the patent office, or sometimes a just application. So we think we are extremely inventive because we have these applications, and so being in this patent game is simply already showing and signaling something. So at least we don't ignore patent, but you can file a patent at the same time ignore patents at all. But she says at the same time we have the objective of secrecy from time to time, and that can make a lot of sense, especially dedicated not to file a patent for a certain whatever business asset. So what would you say? How can that be balanced? And to a certain extent, is a patent attorney a good partner discussing that? Because at the end, I mean, the patent attorney would like a patent. So when I come up and say, should I patent it or should I stay secret? So what is an appropriate reaction to that? And is that also convincing for investors when you say, no, we did not file intentionally because we think it is much more worth or much more meaningful for us when we have a trade secret here? So what is your consulting approach here?
Yeah, firstly, I'm not selling patents. As a patent attorney, I mean, there might be colleagues around who act accordingly, but in my experience, my very personal experience, it is much better to become a trusted advisor. Once the client trusts that you are acting in their interests, then they come with these questions also to you. Otherwise, they try to find that out by surfing the internet, asking Copilot and what have you, which, by the way, is maybe not a good idea, but that's a different topic at all. I think there is, of course, the question is really, really good because, of course, there is this tendency, because rumors are around, that investors expect patents. And what I think is more important than the number of patents or having patents all is whether or not your IP is strategically aligned with your business model. That comes back to the earlier statement. And there are, of course, developments and even inventions which you cannot determine from the outside. So if you have a product to sell, even more so if it's about a method or things which are difficult to protect via patents, if there is something that you cannot take from just buying your product, then of course the question arises, is it a good idea to keep it secret, which has advantages like protection for forever if you want, and if no competitor gets the same idea, and you don't have to show your competitors how it works, and so on and so on. That's all known. But there are also products which you can, by reverse engineering and similar processes, you can get hold of the invention and then compete. For these inventions, I think it is very advisable to file applications, and be it small ones. I mean, there is also a huge difference or huge range between the costs for a patent application. You can have one that costs 10 times the smaller one. So at least there are it's a very broad range. And if you decide, for example, to have an incremental and high resolution IP strategy, then you should maybe not spend so much money on a single application, but then the process is what you protect. So the process of development, not the method of the invention, for clarity. So the balance is really what is the value of that patent application for that business strategy or for that aspect of the product. And I can give you an example, which is the Coca-Cola recipe, which is unknown for, I think, a century or so. it is certainly not IP protected because you cannot read it anywhere in the patent literature I'm aware of, and it's still something that is secret. And you can chemically analyze Coca-Cola to the very smallest part of the drink, but that doesn't mean yet that you can reverse engineer the recipe. And so you know what's in there, but you don't know how to mix it, in which steps to get there. And if you have a product like that, I advise to keep it secret, but then you should really make sure it stays secret. So you don't tell people, don't tell your employees. Only a very, very few small number of people should know of that. And you should make sure that they stay your friends and don't get too competitors and take that with them.
Got you. So IP is sometimes seen as, especially from founders and small and fast growing companies like scale-ups, it is seen as a administrative burden, as a dry, slow process with lots of legal terminology. So it is seen as overall not really helpful for scaling and growing. And oops, that was the wrong one. And here Anna had I think a very important point here, because sometimes this is not said loud. Yeah, because of course the companies know that, especially when they are supported anyhow by institutional supporting schemes like the European Investment Fund or whatever, then they are very aware that they have to take care about IP. But and on a lower level, it is a bit like, is that really my business? And that slows me down to take care about that. So how can we handle this, let's say, attitude, this feeling?
Yeah, so that depends on your perspective on the process, I would say. If you take the perspective of the inventors and the developers, I'm afraid, yes, it is somewhat of an additional work for them, because they need to, at least sit down with a person of management or IP to explain that invention to them. That is maybe necessary, but for the whole firm, I think it is in fact not. The goal is not to be more bureaucratic. We have more than enough bureaucracy on this continent here, and that is not the aim, of course. The aim is to get a lightweight and reliable system that scales with the company. So you need a recurring operational process that always, in small steps, happens along the weeks of the year. So it is, and if it happens regularly, it is not an additional burden, or it's not seen as an additional burden. Maybe there is, of course, you need to sit down with that person, that is for sure, to explain what happened and to report. But actually, you should do that anyway, to report to your management what is going on in the firm, and you can use that opportunity to also formalize what you have done. And then IP also becomes a management tool. It is not only then something to protect you, but also to guide you and to help, being sensible when it comes to the direction of development, for example. But to get back to the question, so that it doesn't slow down growth, maybe one idea is to not do a lot of forms that you have to fill out or so, but to have meetings which are minuted maybe by AI, which is possible today, or by someone who is in the IP team and knows where to listen, therefore by that you get rid of the additional work. If you have someone you trust, then that person can take that task, and proceed, and help also linking the developers to the top management, which is also important, by the way, because documentation and guiding, invention harvesting, all this gets together there. It is very important that management knows what happens in the machine room of the developing.
Yeah, and as I said, maybe it should not be seen as such a separated activity, because when you really try to understand the value contribution of intangibles, whatever it is, from an intellectual property standpoint, whether it is a trade secret or a design right or a trademark, or a patent, an invention, whatever it is, when we understand the role of these intangibles within the context of the business model, it helps us to understand the business model better and the implementation, technical implementation, customer benefits, and so on. So it is simply one perspective of the overall business model discussion, which is ongoing typically in a scale-up. And insofar, I wouldn't separate it as a completely different thing from what the company has to do at all. I think that is also a perspective which could help, not to see it just as an additional burden, which is administrative and slows it down. No, once it is integrated, as you said, once it is integrated in this kind of systematic manner, so you're used to it, how it works, you can practice it, and then it feels only natural, like in the US, for example, where these scale-ups don't do anything without having a deep understanding of the role of IP and intangibles in their business models. But that is maybe what I would like to hear from you a little bit more in detail. So you talk about an IP management system. So what makes the system? I mean, is it just I have a documented process to how to write an invention disclosure?
No, of course. That's a good question, because I can only say no. Of course, it cannot be that simple. It is, of course, more. It is at the end. It becomes a culture, an IP culture that you have to live up to in your company. If you engage with IP in the very early stage of all the developments, that is maybe one of the first steps. Then you get a systematic approach running. It is not a systematic form. That is part of the process, of course, but only the core, maybe. And I'm not sure even whether you should call it that way, because it somehow might imply that you can get rid of the rest. No, this is one important aspect, but only for the mechanical part of the work, if I may say so. So for the drafting of a patent application, it is of course helpful if you have a form where you ask structured questions like what was the prior art, what is the problem, how does your solution look like, and so on. That is of course helpful, but it's actually not the point. The point is that if you start with, for example, sales comes to you and says, well, our market has a desire to have this problem be solved. This should already be something where IP is involved, because you of course can and should make sure that you're free to act there. What is already there by your competitors? What do you have already on that field? Maybe you have already ideas from the prior art that you can monitor, which is, by the way, the biggest source of technical information of mankind by far. So I think more than 90% of the technical knowledge of mankind is documented in patent literature. So there is, of course, this is a source of information. And a source of management, and then you always take your IP people by the hand if you go through that process, and that is what I mean by an IP management system, so that IP is always involved, not last minute before you get to the trade fair and say, well, tomorrow we have something to present, and oops, we found out we don't have filed anything about it, but it would be better. So you call up your patent attorney and ask him or her to have a night shift and to draft something last minute. And normally these ultra urgent things are not that good from a quality perspective, because they have to be quick and dirty.
And of course, it is the opposite of management. It is just a reaction. It is an afterthought. And this is not a creative creation of a meaningful portfolio. This is simply last resort. Konrad said something which I think it's not really a question, but it's a nice comment to what we said earlier, so that IP and IP management should not be a completely separated discipline from the business and the business management. And she says that she mentions startups, but we talk about scale-ups. But this comment is true for both maturity levels of companies. That these landscape, and I like that. I like the terminology of IP landscape, competitive landscape, product landscape, because that explains an environment in which we act, and it is inevitable. We cannot decide that to a certain extent. Once we have a position based on our business model, on our competitive strategy, on our product, then we have a given competitive environment with which we have to deal. And understanding that also, and especially as you said, on the patent perspective, because again, it's not necessary that you like that, but these patents are around you, and they are extremely relevant, or can be extremely relevant for your business success. And insofar, it makes sense to understand where you are. So this kind of landscaping can also be a part of what you said, of these IP management system, which is implemented, a part of the culture, that when I ever ask you, where are you on this landscape, then you can say, I'm here, and I know who all my neighbors are and why, and I observe that. That's a kind of mental of a kind of situational awareness and a mental map which you need to manage. I think that is helpful. What do you think?
Yes, very much. I love the term situational awareness, because that is one of the topics I have to teach my flight students. But apart from that, of course, in the IP world, we also need to have situational awareness, which goes a bit to the direction of the freedom to operate, but also, and maybe even more importantly for a scale up, normally or many times scale ups are not yet that established. So they are developing and moving around. They have a moving target, if you want. And for that, they normally also change cooperation partners from time to time, or sometimes cooperation partners change horses and say, well, it was nice with you, but now we have a new partner. And in that case, it is good that you protect your contribution to the partnership with your cooperation partner, so that you're always in the driver's seat to a certain extent. Of course, you can't force someone else to partner up with you, that's clear. But you can make sure that what you bring to the table, to that partnership, is also protected, so that they cannot easily learn from what you provided and then go on to the maybe cheaper competition, and then you are, it was for you with that cooperation. So the landscaping is the one thing, but if I may come back to my aviation examples, which I always use for obvious reasons, you also need a wingman, so someone who flies along with you and whom you can trust. But trust is nice, but it's of course better that you have also something that ties you in, and or keeps you stay together because of a reciprocal interest, if you want to say.
Got you. No, I mean that is a very important point. That are these molds, and whether can you defend your business model against the competition. Because you mentioned trust, I mean, management and business development and business making has a lot to do with trust. So Maria has another nice point. And that is the question, how do you explain the future? I mean, at the end, when investors come into your company, when they want to invest, they invest in your future, not in your history. And this has a lot to do with trust. And even when you say this patent protect whatever this and that product, even then, or especially then, you have to explain how exactly will that convert into profit, into market shares. I mean, it's nice that you are protected. It's nice that you have a mold, but maybe nobody wants to imitate you. Maybe nobody wants to steal that simply because it's ridiculous or boring or whatever. So these storytelling, this narrative which you need, that is really one can see a value-oriented patent discussion as a training program for meaningful narratives for investors. So is that something how you interact with your companies?
Well, that is very individual, I would say. It is, of course, the observation is true. Of course, there is a difference between the objective fact, maybe, and the subjective view on that. Whether or not your IP strategy is aligned with the business model, but that also depends on the business model. If you have your own business model as a startup, maybe that's a different business model from what your investor has in mind. If that is something you should know then before you get in touch with them, or they know that themselves. So that is something I think it's difficult to answer in general. But I think typically you can say that an IP strategy that is aligned with the business model should, to a certain extent, speak for itself, to be a proxy for the defensibility of your plan that you had, your business model. If that is our business plan, if that is different from a business plan of your investor, then of course you need to be a bit creative and try to find out what their business case is. Why are they interested in your firm as the founder of a scale up, and how does that fit to your IP strategy, to the IP rights? And at that point, maybe it is also clear that you can you can consider one and the same IP right also from different angles. And for that, it's of course good to have someone whom you can trust to draft a high quality patent application, because then chances are that they are more general and you can look at them from different perspectives. For example, what I try with my clients in many cases, so if they allow me to, is filing several applications on aspects so that you have different angles of view on the same development, if you want. But oftentimes there are many aspects in one development, and if you can differentiate that, you have a broader base, and from a broader base you can develop a more flexible, if you want, IP strategy. Because it is difficult it is already difficult to align your IP strategy with your business strategy. I'm aware of that, but it's more difficult to not only align it, but to be flexible at the same time for different business strategies. And that is, of course, something where, again, the systematic approach helps you, because only then you have a chance to harvest all the inventions that you have and try to be as broadly protected as possible. That is the very least or the one of the strongest reasons for you to structurally and systematically and on a regular basis do the filings, or at least the decision on filings or not filings.
So during our discussion, also on the Dplex side, you mentioned these benefits of having a kind of this IP management system ready or in place to be investor or to become investor ready. So could you summarize for us? So now at the end of our discussion, could you summarize these benefits for us, just as a take home message?
Yeah, there are so many. It's difficult to summarize, but if you want, you have one aspect is a stronger credibility with your commercial partners. If you have an IP strategy that is systematically set up, and you can show that to your commercial partners, that is much better than only having a bunch of patents or trademarks to show. Then the expansion to new markets is one of the many benefits that you get if you start the structured approach, because you force yourself to ask a structured list of questions, and one of those questions should be the markets you want to protect your certain aspects. And the improved preparedness for M&A, because if then the famous data room opens up and you get your IP rights there, it's good to have an explanation why they are there, what are they protecting, and so that you can show to them not only what is there but also why. This is maybe one of the most important aspects of this.
Okay, got you. Thank you. And finally, what would you say? So, I mean, we live in a time where people say that data is the new gold, and that data is becoming important, especially when we have data-driven business models. So, what would you say what would you say about the investor readiness of scale-ups in terms of their data and data management? So is that so? What could you say about IP-related data and how that should be presented or could be presented to investors?
I think that is one of the key advantages of IP rights, because IP, intellectual property, is something which is not tangible. It is something you don't have, you cannot really measure without IP. So, and you cannot manage what you cannot measure, and of course, and you have the data only once you have IP. So then you only know you can apply statistics to your IP in terms of your inventions and your tangible and intangible assets, if you want. That is not possible if you don't have IP on that. Otherwise, you would need to find an artificial system to somehow get hold of that. But I think the most promising approach would be a structured harvesting of the data of the invention, then via IP the data, and that is something you can then manage. That is, I think, the best way, actually, and I agree. Data-driven world calls for the IP strategy.
Yeah, perfect. And I mean that is a very good final word, because that reminds us that we should take care about data, and that management is about optimizing KPIs and these kind of things. And we need obviously data to manage it. So thank you very much, Volker. I could talk with you for many more hours, and maybe you come back also to us. So we are through for today. I just want to remind you, we have still open our subject matter experts call. When you're interested, you find our calls here. And just to mention, we will be back at the 25th of June together with Laila May Fafana, and we will talk about IP as a strategic decision tool. So thank you very much, Volker, for these insights, and I hope you are still with us for the next hour on LinkedIn, on our after show party on LinkedIn. So we have some questions still open. I was not able to bring all of them. It would be great if you could answer that and refer to your material, which is online and available for the audience. Thank you very much to you all, and take care and goodbye.
Thank you very much. Bye-bye.